So good morning, everyone. Thank you for joining us for our summer series on financial services regulatory topics. Our housekeeping rules are to keep your cameras off, your microphones muted. We're now on to our second session of the series, the FCA's CASS rules. And after today's session, do feel free to get in touch with myself, our other speaker today, Marianne, or any of Bernice Paul's financial services regulatory team afterwards. If you have any follow-up comments or questions, do feel free to get in touch. This session and others will be recorded and distributed to you afterwards. So housekeeping out of the way, let's delve into CASS. So first things first, what are the CASS rules? So CASS is one of the many acronyms in the financial services regulatory world. It's the acronym for the Financial Conduct Authority's Client Assets Sourcebook. So one of the also many sourcebooks of the FCA handbook. And if a financial services provider either holds or controls client money or assets, then they must follow the rules set out in the FCA's Client Assets Sourcebook, or CASS. And the main purpose of the CASS rules is to ensure that client assets are safeguarded and, importantly, returned to customers in the event of firm failure. Protecting customers in the event of firm failure is very much a current priority of the FCA, as seen in its recent 3-year strategy and this year's business plan. And the way that the CASS rules achieve this purpose is by mandating that firms keep all client money separate from the firm's own money, by preventing firms from using client money for their own purposes, by ensuring that firms maintain accurate and up-to-date records of the client assets they hold, also ensuring that the rules are given priority within firms, so firms are required to appoint a person to have CASS operational oversight, overseeing compliance with the CASS rules. And the rules also require that firms carry out CASS-focused audits and regular returns. So what are the origins of CASS? If we just go on to the next slide. So the CASS rules, as we know them now, were developed following the collapse of Lehman Brothers in 2008 and also later the investment bank MF Global in 2012. These cases exposed failings in the client asset regime of the Financial Conduct Authority's predecessor, the Financial Services Authority. The cases exposed that despite there being a client asset regime, clients were not receiving their money back in a timely fashion, if at all. An ongoing litigation in relation to Lehman Brothers International Europe Limited forced the hand of the then FSA to rethink its client asset rules. The first update was a new chapter inserted into CASS, which required that certain investment firms were to have in place CASS resolution packs. And a significant development then stemmed from the UK Supreme Court decision of the 2012 Lehman Brothers and Administration case. And this citation should be there on the slide. In that case, the Supreme Court held that a trust is created when a firm receives money from a client and not when the money is segregated into client accounts. All client money should be pooled upon failure of a firm, irrespective of whether or not it was in client accounts. So in other words, it's not just when it is segregated client money in designated accounts. It also held that all clients with a contractual entitlement to client money protection are entitled to participate in the client money pool, even if their money was not segregated. So following this Supreme Court decision, now at the heart of the operation of CASS is the concept of a statutory trust under which client money is held. The creation of a statutory trust means that client money is not a firm's property, rather it is held in a fiduciary capacity or by a firm as agent on behalf of the client. So if we go on to the next slide, please. Okay, so CASS classification. So the CASS rules will apply to those firms which hold or control client money or assets, as we now know, and these firms are categorised based on the size of client money or custody asset holdings, or both. So firms are classified as either small, medium, or large. So CASS small firms are defined as holding client money assets below 1 million, or safe custody assets with a value below 10 million. CASS medium firms hold client money of between 1 million and 1 billion, so that's inclusive, or safe custody assets with a value between 10 million and 100 billion, that's also inclusive. And then CASS large firms hold client money in excess of 1 billion or safe custody assets in excess of 100 billion, so quite a lot for the large firms. Firms must make notifications about the money and assets they hold or are projected to hold to identify if the firm is a small, medium or large firm. So for some firms, this will be in the form of an annual questionnaire. For other firms, the FCA will assess this based on past CMARs. And while we're on the topic of CMARs, this refers to the client money and asset return. So if a firm is categorised as medium or large, so it holds client money equal to over 1 million and or safe custody assets equal to or over 10 million, then it must complete and submit a CMAR to the FCA every month. And that return has specific questions which give the FCA an overview of the firm's client money and safe custody assets. Small firms do not need to complete a CMAR, but should complete the annual questionnaire. So taking us on to the CASS rules themselves, if we'll go on to the next slide. So these rules sit alongside Principle 10 of the FCA Handbook, which states that a firm must arrange adequate protection for client assets when it is responsible for them. So it's worth noting that the term client includes every category of client. So that's not just retail clients, but professional clients and eligible counterparties. And as these terms are defined within the handbook, so the handbook gives the definitions there. So we won't have time to go into every aspect, every chapter of CASS, but some key ones to mention, which I've noted on the slide there. So first off, we have CASS 3, which is relevant to collateral. So these rules apply when a firm is given the right to use a client's custody assets and treats the assets as if all legal rights have been transferred to it, subject to returning the assets once the client has discharged its obligations. We've then got CASS 5. This deals with client money arising in relation to insurance distribution activities. I've been dealing with CASS 5 quite a lot recently. So this chapter is relevant not just to insurers themselves, but to brokers and sub-brokers and anyone arranged with insurance distribution activities. Under CASS 6 are the custody rules, and these apply to when a firm is safeguarding and administering custody assets, and these are designated investments and other assets held in the same portfolio. So CASS 6 outlines the rules with which regulated firms must comply with when they are safeguarding and administering investments. We've also got CASS 7, that's the client money rules, also one you may have come across. And these apply when a firm receives or holds money in the course of or in connection with its MiFID or designated investment business. CASS 7 governs how a firm must safeguard and handle client money held in relation to its investment business. And these rules flesh out in more detail on Principle 10, that a firm must arrange adequate protection for client assets when it is responsible for them. CASS 7A covers client money distribution. So these rules will come into play on the failure of a firm or a third party where client money is held and it seeks to help the timely return of that money. CASS A is applicable to mandates. This chapter applies when a firm can control but does not hold custody assets and client money. CASS 10 requires certain investment firms to prepare and maintain resolution packs, which will contain information that will assist an insolvency practitioner in the prompt return of client money and safe custody assets following that firm's failure. And these rules were introduced on the 1st of October 2012, largely in response to the Lehman Brothers administration. So it was one of the first revamps of the CASS rules. CASS 11 governs debt management client money. The rules require that all debt management firms to comply with the key aspects of the FCA's client money regime, while applying a slightly lighter touch in some areas to firms with smaller balances of client money to reflect the lower risks in such cases. A large firm for these purposes under this chapter is one that held £1 million or more of client money at any point in the previous calendar year, or expects to do so in the current year. And then finishing up on the last one, so we've got through quite a few of the chapters. So that's CASS 13, which is the rules for claims management client money. So claims management companies are one of the newer financial services firms to come within the scope of FCA regulation, and CASS 13 is the relevant chapter for CMCs. So there's a number of different financial services firms that are caught by the scope of the CASS rules, but how important is this particular source book to the regulator? And to discuss that, I'm now going to pass you over to my colleague Marianne. She'll be discussing auditing and, more excitingly, enforcement of the CASS rules. So we'll hear some examples of some cases. So I will now pass you over to Marianne.
Thanks, Sylvia, and morning, everyone. So now that Sylvia has provided an overview of what the CASS rules are, I'm going to cover what happens in the event of a breach. And in the latter half of this section, I will give some examples of firms and individuals that have been hit with some hefty penalties by the regulator as a result of not adhering to the rules which are incumbent on them. So in terms of CASS breaches, one way that a firm might be alerted to the fact that they're in breach of the rules is if an audit has been carried out in accordance with the FCA's rules. And I'll briefly discuss the audit requirements under the CASS regime. So the rules can be found in SUP 3, which is the supervision manual within the FCA handbook. And all regulated investment firms that hold client money and or custody assets in relation to their regulated activities, with limited exceptions, require a CASS audit to be undertaken on an annual basis and for an audit report to thereafter be produced and sent to the FCA. In general, insurance intermediaries must have a client assets report completed, but are not obliged to send it to the FCA. And the obligation is on the firm to appoint an external auditor to produce the report, and the relevant rules regarding what the report must contain are set out in SUP 3.10. So in accordance with the rules, the CASS auditor must prepare a report giving two opinions. One, whether the firm has maintained systems adequate to enable it to comply with the relevant rules throughout the period. And two, whether the firm is in compliance with those rules at the end of the period. The report should provide a reasonable assurance on the client money and or custody assets held by the firm. And if the firm claims not to have held client money or custody assets, or is not authorised to do so, then the auditor should provide what's known as a limited assurance report. And some further requirements regarding the auditor's report are that it's prepared using the template provided within SUP. It covers a period of no more than 53 weeks, starting from the date of the last report, or if it's the first one, starting from the time a report was first required. It should be submitted within 4 months of the period end date, and it should be signed by the person in the audit firm who had the primary responsibility for it. And it's each firm's responsibility to ensure that the auditor they appoint is appropriately qualified and that the report they provide is in line with the requirements. Firms, including their appointed representatives and tied agents, must cooperate with auditors and provide them with relevant information. It's an offence under section 346 of FSMA to knowingly or recklessly give false information to an auditor. In doing so, it could make that person liable to imprisonment. So what happens if breaches are identified in the auditor's report? Well, auditors are required to prepare a separate template schedule identifying the CASS real breaches noted during the period covered by the report. If any breaches are identified, then firms are expected to provide comments on actions taken and or any mitigating factors. And of course, CASS breaches could be identified by a firm before an audit has taken place. And in fact, self-identifying and remediating a breach is a far better outcome than it being identified by an auditor or the regulator itself. And there are certain matters which the FCA expects to be immediately notified of, which are contained in the CASS rules. And these includes, for example, if a firm is unable to carry out a reconciliation or is unable to pay any shortfall into a client's bank account. If there is no specific notification requirement under CASS, then firms should make an assessment based on their risk appetite or standard approach as to whether or not a breach is material enough to be notifiable under Principle 11. So going on to the next slide, please. We will be dealing with FCA supervision. So compliance with the CASS regime has been subject to significant ongoing supervisory engagement in recent years, reflecting its importance to the regulator. And CASS will continue to be a priority area for the FCA, and it's very much at the heart and focus of its business plan. So in terms of how the FCA approaches supervision, well, we know that it's got limited resources and it must prioritise its focus. Firms with assets of greater than 100 billion and money greater than 1 billion, i.e. those classed as large firms for CASS purposes, they get more supervisory attention than their smaller counterparts. This is just given that they've got a greater ability to impact consumers if things go wrong. And in the UK investment markets, there are certain large players that hold the majority of CASS holdings. And they'll naturally face the most supervision from the regulator, given the vital importance that they play in ensuring market integrity and stability. The FCA has a dedicated client assets unit to supervise compliance with the rules, and this unit brings together specialist risk, supervision, and policy functions. The unit was established in 2010 to address concerns relating to client money risk, which were highlighted during the financial crisis. And the FCA gathers data about the CASS compliance of a firm via multiple avenues. So they can do so either by sending information requests, and these could be triggered by an incident reported by the firm itself, or it could be that there's a particular area of interest to the FCA. Another avenue is through the client money and asset returns, the CMARs or audit reports, and these are both looked at by the regulator, so it's important that firms ensure their accuracy. So moving on to the next slide, which is penalties. If a firm falls foul of the rules, then the FCA is able to use its normal range of sanctions and disciplinary powers available to it under FSMA. And these are, for example, public statements and public censure, financial penalties, withdrawal or suspension of a firm's authorisation, or suspension or prohibition on an individual conducting regulated activities. And of course, firms committing breaches would suffer reputational damage. So the next slide discusses FCA enforcement. And there are numerous enforcement cases relating to breaches of client money and safe custody assets. Asset rules, and this demonstrates the priority that the FCA attaches to a high level of compliance in this area. And I'll take you through a few examples of final notices which were issued by the FCA against individuals and firms following breaches of CASS requirements and the FCA's principles for businesses. And then I will draw on common themes arising from recent enforcement cases. So the first one here is a case against Charles Schwab UK. This was a final notice issued against Charles Schwab UK Limited in December 2020, and the firm was handed down a fine of £9 million over safeguarding and compliance failures. So what happened? Well, after a change in the firm's business model, client money was moved from the UK firm to its parent, which was based in the US. And client assets, which were subject to UK rules, were held in the US parent firm's general pool, which contained both firm and client money and which was held for both UK and non-UK clients. It was found that the UK firm had failed to adequately protect client assets under UK rules, by not having the right records and accounts to identify its customers' client assets, by failing to undertake internal or external reconciliations for its customers' client assets, for failing to have adequate organisation arrangements to safeguard client assets, and for failing to maintain a resolution pack, which would help to ensure a timely return of client assets in an insolvency. And a key concern for the regulator was that in the event of the UK firm's insolvency, an insolvency practitioner would need to obtain books and records from the third-party US parent company, would not be able to identify the client assets and client money owing to the UK firm's customers, and would not be able to easily access those funds. In this case is a key example that a firm is unable to outsource its responsibility for compliance with CASS. So moving on to the next slide and the second enforcement example, this is a case against an individual, Darren Newton, in December 2018. So the FCA banned Mr. Newton from working in the financial services sector after discovering that he used customers' money for the purchase of a debt management firm, First Step Finance Limited. Mr. Newton purchased First Step through his company, and for a period of time, he was the sole director of First Step. He funded the purchase from the accounts of First Step with client money rather than his own funds. And he directed or allowed over £322,000 to be transferred from the First Step accounts to the seller of the company. And this showed a serious lack of honesty and integrity, and the FCA unsurprisingly deemed that he was not a fit and proper person. So moving on to the next slide is our last enforcement case example against the Bank of New York Mellon. So in 2015, the FCA fined Bank of New York Mellon a total of £180 million. This was reduced to £126 million on account of early settlement. But BNY was found to have failed to adequately arrange protection of safe custody assets as required by Principle 10 of its Principles for Business. And the bank's fine relates to breaches of the FCA's custody rules over a 6-year period from 2007 to 2013. And it was the largest fine ever levied by the FCA for client money failings. The FCA branded the bank's compliance with the custody rules as seriously inadequate. Particular concerns included failures to safeguard client assets, maintain entity-specific books and records, conduct reconciliations, segregate assets, implement CASS-specific governance arrangements, provide CASS-specific training, and submit an accurate CMAR. So really a whole host of failings were found. And the FCA Director of Enforcement at the time said that the size of the fine represented the value of safe custody assets by the firm, as well as the seriousness of the failings and the fact that the failings were not identified by the firm's own compliance monitoring. So finally, taking us on to the next slides, which is common themes. There are a number of common themes that can be drawn from the final notices which have been issued by the FCA for breaches of CASS rules. And it's clear that the FCA will take action even in circumstances where there's been no loss to clients. And common breaches over the years include failures by firms to identify when client money is actually being held, ensuring that when client money is held, it's protected by way of segregated accounts, have robust client money procedures relating to reconciliations and records in place, train staff so that they're familiar with client money rules, guidance and laws, and submit accurate client money and asset returns. So hopefully this all shows that CASS compliance shouldn't just be seen as an administrative burden or a tick box exercise, as the FCA really does take it seriously and will undoubtedly continue to do so. And that brings us to the end of our webinar, finishing up slightly early, but thanks very much for joining. We hope that you found that informative. If you have any questions, then don't hesitate to drop Sylvia or I a message. And we hope to see you next week, where we will be discussing the regulation of crypto. So thanks again, and enjoy the rest of your days.